Greetings. In this lecture, we move to the third and what for the Supreme Court has been the most elusive of the freedom of speech issues, and that is pornography and obscenity. The Supreme Court for over half a century has said that pornography is protected by the First Amendment, but obscenity isn't. Obscenity is criminal behavior that is not protected by the First Amendment. And so the intriguing and really difficult question is, well, when does pornography cross the line and become obscene? I do believe that the best statement on this by a Supreme Court justice, and it's a very old one, goes all the way back to 1964 with Potter Stewart. Justice Stewart was leaving the Supreme Court building, and a reporter said, Justice Stewart, the Supreme Court has been taking up a lot of time with this issue of pornography and obscenity. And in your mind, when does pornography cross the line and become obscene? And Potter Stewart paused for a moment and said, I don't know if today I can tell you what is embraced within the shorthand description of obscenity, although I do believe that cases involving obscenity are cases involving hardcore pornography only. But so I don't know what is embraced within that shorthand description, obscenity, and I don't know if I will ever succeed in intelligibly doing so. And then he smiled at the reporter and said, but I know it when I see it. And of course, that is what makes this issue so very difficult, is that each and every one of us knows if material is offensive to us personally or not, but then trying to operationalize it and to come up with a national standard for what may or may not be obscene is incredibly difficult. The issue of obscenity goes back before the creation of our country. The first law that I've ever found regarding with obscenity goes back to the colonial period in 1714, when the colony of Massachusetts made it a crime to publish any filthy, obscene, or profane song. Boy, would they have fun with that today, given the music that's out. Pamphlet or mock sermon, and apparently it was the mock sermons that were the big difficulty. The Puritans apparently were changing a lot of the thou shalt nots in the Bible to thou shalts. From 1842 to 1956, the U.S. Congress was very, very active in this area of obscenity, passing 20 federal obscenity laws. And yet during this entire time, the U.S. Supreme Court stayed out of the issue of obscenity. Instead, the lower courts relied on a very old English standard called the Hickman Standard that goes back to 1868. But that changed in the 1950s. In 1953, we get a new Supreme Court justice. The previous Chief Justice of the Supreme Court, Fred Vinson, died suddenly of a massive heart attack. The President, Eisenhower, nominated the new Chief Justice, who happened to be the three-time Governor of California, Earl Warren. And Earl Warren was the first to take on this issue of what may or may not be obscene. Now, even though I rank, and you guys know how I love to rank everything, I believe that Earl Warren is the second greatest Chief Justice that we've ever had in American history. Chief Justice Warren has some blind spots. And frankly, one of them for me is this area of pornography and obscenity. The new Chief Justice Warren, essentially divided sexual material between what he determined was, quote, normal sex, so you can think in your mind what that might be. For Chief Justice Warren, this was adult heterosexual behavior. In essence, Chief Justice Warren believed that, if that's something that I would do, then that's normal sex and it should be protected by the First Amendment. He then determined that other sexual behavior was deviant sex, and in several cases, the Chief Justice refused to protect this material. Two very famous examples of this involved a homosexual publisher and a sadomasochistic publisher in two cases in 1966 called the Mishkin cases and the Ginsburg case. And in these two cases, Chief Justice Warren allowed the sadomasochistic publisher and the homosexual publisher to go to prison. In these cases, there was a very strongly worded dissent from Justice Douglas, who in essence said that Chief Justice Warren was guilty of what I entitled this section, Civil Liberties for Me but Not Thee. And in essence, what Justice Douglas said, in case after case after case, you have protected material on the flimsiest of grounds if it is what you have determined is normal sex. Now we have two publishers, a homosexual and a sadomasochist, who define their sexuality different, and you send them to prison. Shame on you. If communication by the written word has therapeutical value for those of the normal community, then why doesn't communication by the written word have communication for those of the minority or deviant community? And I think that Justice Douglas has something very, very powerful to say. Looking at your notes, the first time the Supreme Court took on this issue of pornography versus obscenity was in the case of Roth versus the United States. Mr. Roth was convicted by a jury in New York for mailing obscene circulars from Los Angeles. The basic issue in the Roth case is, does the First Amendment protect obscene speech? And of course, in your notes I have written, this was the first case in which the U.S. Supreme Court ruled that obscenity is not protected by the First Amendment. However, remember that Warren wants to protect what he determines to be normal sex. So in this case, the Supreme Court ruled that to be obscene, material must be utterly without redeeming social value or importance. And so in other words, all ideas having even the slightest redeeming social value are going to be protected. And so you saw a reaction in the adult film industry and in magazines. For example, one of the reactions from a fairly new magazine, Playboy magazine, was to have the Playboy interview, an interview with a famous person that would give this magazine, quote, redeeming value. The most popular ending to porn movies in the late 50s and early 60s was for the young woman who's been involved in 30 to 60 minutes of debauchery to run off to a convent or nunnery to renounce her evil ways. God gets the girl in the end. What could be more redeeming than that? And so the Warren Court, and Earl Warren was the Chief Justice of the Supreme Court from 1953 through the 1969 term, Warren was determined to protect this material. Critics of Warren, however, said that the Supreme Court never really established any guidelines or definitions for what material might be protected or not. In the second case, in your notes, this is a Supreme Court case that I used. You remember the very first week of the semester, Stanley versus Georgia. This was the Supreme Court case that I illustrated the paradox between majority rule and minority rights. And in Stanley versus Georgia, the Supreme Court by a 9-0 margin ruled that the state of Georgia could not ban the private possession of pornography, that the private possession of pornography is protected in this case. Now, the bigger issue in this particular case that I did not put in your notes, but that you may want to list in parentheses, is that this Supreme Court case to me is really, really important, because this Supreme Court case is a Supreme Court case that helped establish an implied right to privacy. And certainly, while the right to privacy is usually associated with Roe versus Wade, the landmark abortion decision, the Warren Court really established an implied right to privacy in this case, Stanley versus Georgia, as well as in a series of criminal defendant rights cases. So, for example, later on, when I talk about the Fourth Amendment and protection from unreasonable searches and seizures, that landmark case of Mapp versus Ohio, where the Supreme Court in this case ruled that the Ohio authorities had engaged in an illegal search because they didn't have a valid search warrant. In that particular case, just like in Stanley versus Georgia, the Warren Court on multiple occasions established this notion that there is an implied, it's not enumerated, there is not a constitutional amendment that says that you have the right to privacy, but certainly the Warren Court set it up for the Burger Court in Roe versus Wade to articulate this implied right to privacy. Now, one of the problems during the Warren years, and a second criticism, and I'm going to get into this one in the next tape, is that critics of Warren said that Earl Warren was trying to do something that is not very realistic, and that is that Warren is trying to establish a national standard for what is obscene. And of course, I talked earlier about how we are a country of federalism, how community standards and state standards vary in a whole variety of ways. And that's why, for example, some states like California allow for direct democracy, for voters to engage in the initiative, the referendum, and recall, and most southern states do not. Some states have a speed limit of 65 miles an hour, others have 70, 75, or 80. And so critics of Warren said that if we are going to be a federal country, and if we are going to allow people in different states to have different standards, then perhaps community standards is appropriate in the arena of obscenity and pornography. That what may be obscene, for example, in the city of San Francisco, which isn't very much, almost anything goes in the city of San Francisco, might be very, very different than in a small town in Mississippi or Georgia or Alabama, or if you want to use a western state, perhaps Salt Lake City. And so the big criticism of Warren was that from 1957 throughout the 12 years that he was Chief Justice up until 1969, the Supreme Court tried to establish a very elusive national standard for obscenity and pornography, and they never were really successful. So when Warren retired in 1969, we get a new Chief Justice, Chief Justice Burger, and Chief Justice Burger tries for 4 more years to come up with a national standard for obscenity and pornography, and he discovers that he's not being very successful either. And so Chief Justice Burger changed the tenor of discussions. We get a very, very famous case. In fact, it's probably the most famous pornography case to ever reach the Supreme Court case. It's a case called Miller versus California in 1973. It's usually called the Orgies Illustrated case. And in the next mini lecture, I'm going to talk about Miller versus California, because what is significant about Miller versus California is the Supreme Court decides to adopt community standards in this case, saying that instead of having one national standard for the whole country, we are going to allow states and even communities to define their own standards for what might be obscene. And so that opens up the door for a variety of standards throughout the country, depending on the values of those communities.